As always, it's appreciated. Hello, everybody, and again, welcome to Announcer Prevention, Policies, Procedures, and Proactivity. This is the second webinar in the seven webinar series, Protecting Your Employee Assets, the Life Cycle and Employment Relationship 2026. Slide 5 on the PowerPoint is our disclaimer, and that reminds you that you can't go out and make important business decisions based on what you learn here today. This is purely informational. We're not your advisors or attorneys, and you're not our clients. We're only giving general knowledge here. Also, that we're not going to lecture off the slides, and we're not going to go through the slides in order, and we're not going to sit here reading the slides to you. This is really a conversation amongst the four of us, with myself moderating. You can learn more about financial poise on slide number 45. Also, slides number 7 through 9 summarize the series and this particular episode. As always, our panelists today are Max Barrick, partner at the Garfinkel Group, Helen Black of the law offices of Helen Black, and Katie Rinkus, partner at the Prince Law Firm. And again, I'm Chuck Krugel, a management side labor and employment lawyer. You can learn more about us on slides 39 through 42 of the PowerPoint. And as Michael said, you could submit questions using the web portal, or if you're watching this on demand or have questions after the webinar, you can send an email to info@financialpoise.com. Just include your question and the name of the webinar episode, and we'll do our best to get you an answer ASAP. Thanks to our sponsor, the National Law Review. Slides number, there are more about them on slides 3 and 43. All right, with all that out of the way, let's get going. So, Helen, let's start with handbooks. How essential are handbooks today? Do businesses really need these, or do they need comprehensive, like A to Z type of handbooks? What do you think is best?
So it depends on the size of the employer and a number of factors. So for instance, if let's say you have a very small employer that has 1, 2, less than 5 employees, they might not necessarily need a handbook, certainly not the same kind of handbook as an employer that has over 25 or over 50 employees. For a super small employer, they probably just need something in
Helen, you froze.
has sexual
Helen, you
harassment
froze.
policy and anti-discrimination on.
Helen, you froze for a couple
Um,
seconds.
okay. Okay, did I unfreeze now?
Yeah, you're okay right now.
Okay. Okay. So I don't know. Let me start over again. In answer to your question, Chuck, whether an employer needs a handbook, it's really dependent upon the employer. There's no one size fits all approach. It depends on the size of the employer. So an employer that, let's say, has 5 or less employees is not going to require, if they decide to have a handbook, the same kind of a written handbook as, let's say, an employer with 25 or over 50 employees. If someone has, let's say, just a handful or less employees, perhaps it would be prudent to have a sexual harassment policy in writing, or other types of policies that might be mandated by local or state law in the jurisdiction where the business is located. There are also a lot of different government agencies that require certain policies to certain posters to be displayed in the work site that have certain policy statements in it, such as an anti-harassment policy or discrimination or an accommodation kind of policy. And it could be sufficient for a really small employer just to basically cobble together the different government required postings as part of their handbook. Now, certainly once you have more than a certain number of employees, I would highly, highly encourage a handbook to be put together and distributed at the place of employment. So this way, everyone's on the same page and follows the same rules. When you have a smaller employer, it's easier to have some kind of flexibility, but with a larger employer, you lose the opportunity to really have flexibility, because if you don't treat similarly situated employees the same, you open yourself up to disparate impact and discrimination claims.
Thanks. And just a quick note for everybody, you may want to include biometric information gathering if you engage in biometric information gathering, and also AI disclosures in handbooks. Although be careful, because in some jurisdictions, even putting it in a handbook as a general policy won't be sufficient enough, because you may have to do it for each time that you actually gather that information. So just to add something about that.
On the AI point, Chuck, too, there's a flurry of statutory provisions that are going in various states right now. I know Illinois is
Uh,
sort of rushing to implement regulations on that through the Department of Human Rights. That's just local to Illinois for folks, but just keep monitoring these things because it's going to be fluid for a while.
well, I think Illinois is a good example because I think we're the most restrictive state in the nation when it comes to biometric information and AI. So, more
Yeah, and right
restrictive even
now,
than
yeah,
California.
and right now because a law was recently passed, we really don't know what it encompasses. So, for instance, in
Yeah.
Illinois, there was a law that was passed that says, if you're going to use AI in employment decision making, you have to let your employees know. Well, what's the scope of that? What constitutes, decision making and so on. And so right now, I think the state is promulgating the parameters of that. So really everyone is kind of up in the air right now and doesn't even know what that means or what it entails. I don't know, maybe Max or Katie, you can shed some light on this. I certainly don't know what the scope is yet.
They drafted the law without any regulations. That's what it amounts to.
I mean,
And
I think we saw a lot of that during the pandemic, right? Like that's not, I'm sorry, Katie, I didn't mean to talk over you.
I didn't say anything. Then go
And
ahead.
I'm losing my mind, guys. I was just going to say, I think it's sort of akin to what we saw during bits of the pandemic early when the Families First Coronavirus Relief Act, the FFCRA, got passed. Like Congress would pass something Monday, and by Wednesday, the DOL was rushing out half-baked regulations. Webinars were coming out, and then a week later, they were getting, you know, fine-tuned and revised and pared back or strengthened based on the feedback they got. So, I think like a lot of things, sort of do what the law requires when and how you can. If it's the kind of thing that you're not comfortable with or you're not sure it's possible for you to comply, consider delaying things that may expose you down the road or just cause headaches that you can't confirm are going to be legally kosher, I guess is the way I would say it.
thanks. So, Katie, there's a ton of free resources on the internet when it comes to handbooks and policy development. If you Google employee handbooks in quotation marks, you'll get it more than 500,000 responses. Um, are these good resources to use? Will these be sufficient? And also, what about using AI to create a handbook or policies?
Yeah, I mean, I think the number one issue I see my clients when they either have a handbook they want me to review, well, usually if they have a handbook, is they just used a form template they found, or someone sent them a handbook that they use at their business and now they're using it, but they're not the same businesses and they have completely different employees and workforces. So as with anything on the internet and on using AI, sure, yeah, you can do some initial research with Google or dare I say it, ChatGPT, like to get a sense of what you should include in these employee handbooks. But I certainly would highly caution against employers from just like finding a handbook you online and using it. Because as we'll discuss later, like your handbook really is that's one of the first things that your employees see as like part of your business, and it really is a chance for the business to set the tone and culture and like get across what is important at the business and also like legally important terms, right? Anti-discrimination, anti-harassment. So if you have a handbook that doesn't like that you have policies in there that you don't know what they are or that you don't even follow, what's the point of even having a handbook? It could actually come in like it could hurt you in the future if there's ever some type of employment claim. So, definitely use the internet and AI for those resources. But even if you don't use an attorney, I'm not trying to say you have to use an attorney to do a handbook, but like there are a lot of HR professionals out there who
Yeah.
know a lot about this stuff who can help you. But there are some definitely like if you have employees in multiple states, you need to make sure that your leave laws comply with all of that. If you're like right at that threshold of 50 employees, as Helen mentioned, like that's when a lot of the big laws are going to be important for you. So if you just pull something off the internet doesn't necessarily know like the ins and outs of your business, right? Like how could it? So I would definitely caution employers from just kind of taking that like fast approach because it could come bite them in the future.
All of us, to some extent or another, we read handbooks and we get involved in handbook reviews, and our clients use them. Anybody want to toss out like what percentage they think like the of their clients or the handbooks they've reviewed are really on point for the business, relevant to the business, and don't appear canned?
I mean, only
Rarely.
those I've ever really seen in litigation context for like Fortune 500 or publicly traded companies. Like, unless it's most of the time, those companies really are shelling out because they've got large labor forces. They are, I think they're big enough where they're doing, if not actuarial assessments, then they certainly have a sense of what their typical exposure rate is year to year and what sort of labor problems they consistently encounter. And that doesn't just mean legal stuff, timekeeping, other issues that can
Yeah,
spiral into legal, but are more just running headaches for them. So, I mean, those companies I tend to think are much more on the ball just because they have the resources and means and motivation to do that. Um, that said, I think also a lot of financial organizations, ones that act as fiduciaries, are subject to a lot of other regulatory requirements. I tend to find are at least nodding to these issues better because they're already sort of attuned to regulatory exposure they can face. But a lot of mom and pop shops, I think, just my experience is they outgrow that state and they don't really realize they've outgrown being a plucky startup or mom and pop business until after something happens that they're not prepared for.
thanks.
Yeah, and like most of the core terms are going to be very similar across industries, like, right? But they're like, for example, we have a lot of law firm clients, and kind of like what Max just mentioned, like if you're in a professional setting, like those handbooks are a little bit different depending on or clients in the healthcare industry because you probably have to put in like HIPAA information and everything. So I'm at a certain point, like you do have to be very cognizant that of what your handbook should include given the industry you're in and also like the type of workforce. Because if you have a lot of manufacturing employees, like you're going to have language in there about, if they drive company vehicles or certainly like health and safety, as opposed to if your employees are mostly office workers. Just things to take into consideration.
Thanks. So, Max, how often should a handbook be reviewed or updated?
Never set it and forget it.
Yeah,
Don't do that. I was kidding. I'm sorry. Um, I think the bare minimum, and I wouldn't say this even really does it, is annually. Like, if nothing else, at least check at the end of the year or towards the end of the year, like, okay, what changed this year? But I think that even speaks to like, that's probably not enough because you don't know unless you live in a state where there are legislative changes that are set to go into play the next year, or there's some procedural reason that it's unlikely for things to change immediately or retroactively, don't assume that's going to be enough. So, for example, and again, I know Illinois is not the whole country, but like over the last several years, there have been quite a few different laws that have been phased in locally and at the state level. Where if you were waiting till the end of the year, if you hadn't written that stuff in preemptively, you were going to be out of date. Things like the minimum wage rate changing on July 1st, penalties for certain laws changing, or notice requirements changing mid-year. Like what disclosures and requirements exist may or may not be the same on January 1st that it is on July 1st. So be aware of pending changes and either phase them in or be prepared with supplements and notices more periodically. But I do think, a lot of management side attorneys and HR types and professional employment organizations often release legal updates periodically or monthly as they come. And so be paying attention to that stuff because you may have, I mean, as we've been talking about already, quite a bit may happen in the interim that leaves you a little exposed. Um, and I think too, like multi-state employers or companies that start off in a state mid-year, like you need to be aware of what's coming. For anybody who has reviewed a contract of an employee of a large organization that's in many states or across the country or litigates with an organization like that, most of their employee handbooks come with disclaimers depending on the issue of, except for California, or if it's non-competes or
yeah,
restrictive covenants, except for like California, New York, Minnesota, Illinois, something like that. So you just, I think there's no one size fits all at a bare minimum, and that's not even enough annually. But realistically, you need to be paying attention to what the law is and whether quarterly or monthly just to check. It's probably at least worth looking.
Thanks. Helen, I see a lot of handbooks and policies that use jargon and legalese, especially the disclaimers like employment at will or at will employment, and that we were not establishing contractual relationship by hiring you. Do these disclaimers really help? Does it make they make handbooks and policies better?
They can. It then depends on the rest of the language in the handbook. So you can't just throw in, because it sounds good, an isolated statement like, nothing herein changes the at-will nature of the employment relationship. This is not a contract for employment. And then have other language in the handbook that contradicts that. That says, for instance, employees are absolutely required to give 30 days advance written notice before they separate from employment. Because inherently then you have a conflict between, is the employment at will, or is there a contract for a definite period of time? If you put in language that says you have to give 30 days written notice, it's no longer at will employment, because at will employment by nature means you can quit anytime you want without having to give any notice. So it is important to have, if let's say if in general the workforce is at will, then it is good to have that caveat in the handbook that this employment handbook is not a contract. It's really a recitation of the policies, and these are guidelines, and that it is at will employment, and nothing in this handbook is going to change the at will nature of employment. Okay, so yes, have that in there, but be sure that it truly is at will and that you don't have any other language that contradicts that statement in your handbook. Otherwise, it is going to be looked at as just boilerplate and that it's not going to be enforceable. And the opposite could happen. Your handbook could then be used against the employer as a contract, that it is a contract, for employment.
Thanks. I guess to add on too, what if you have policies in the handbook that don't actually apply, that legally don't even apply to you, but you still put them in there, like maybe FMLA, which is 50 or more employees?
So that is a sticky wick. So yes, if an employer has less than 50 employees, but they put language in their handbook that says that we provide family medical leave, and this is what we provide, then yes, a court is going to look to that and say it is in a way a contract with your employee to provide that benefit, because you are holding yourself out as providing that benefit to your employee. Your employee can rely on the fact that you are providing these benefits, which is why I caution folks that they really should not use boilerplate handbooks without reading every single word to make sure it actually fits their culture and actually fits their place of employment. They don't unwittingly give benefits to folks when legally they don't have to give those benefits. Because if they do give those benefits, it will be looked at as though it is a contract with the employee to provide those kind of benefits. And that language in there about this is not a contract, you're right, it might not be a contract for a duration of employment, but it is essentially an employment agreement that you are agreeing to provide those benefits to your employees. Otherwise, why is it in your handbook? And so that's why it is very important for the employer to really recognize that it's better to have the correct thing, going back to what Katie said before, it's better to have the correct thing in writing. And if you can't get it correct, it's better to have nothing then in writing, because you will be held to what you put in writing to your employees.
I see all the time people put in FMLA language, and I'm like, how many employees do you have? And they're like, oh, 10. Like, well, you don't have to give FMLA, and it's because I think it is in so many handbooks, but it doesn't apply to like the just your startup small business. That's a really good example.
That's a perfect example, because I see that routinely as well. Why are you giving this benefit unless you really want to?
I mean, I'll share, I resolved a rather sizable workers' compensation retaliatory discharge and FMLA case this year. And a big driver of the damages was the fact that the company slapped that FMLA language into a handbook that otherwise would not have hit the size requirements. And there's case law out there that says that obligates you, right? So you can, like, that was probably a six-figure mistake on their part,
Well, thanks, everybody. Uh, Katie, what are some of the hot topics in handbooks and policies these days? I know we mentioned briefly AI and uh, biometric information, but what else is there?
Yeah, I mean, I have been asking clients if they want to include AI policies, and usually they say, yeah, some type of, so that's a hot topic. But if we're talking about like really important stuff, if you're going to have a handbook like that you need in your handbook, certainly anti-discrimination, anti-harassment language, anti-retaliation. If someone does think that they're being discriminated or harassed in the workplace, what do they do? So who do they go to um, report that? What is the process for internally with the company for investigating that complaint? And this is where you also need to make sure that you're aware of the laws. And so using an attorney probably because some states like Illinois require, and New York, I believe, require in the handbook that you put information that for outside resolution. So it basically says like if you don't want to go to the company, or if you do, you still have a right to go to the EEOC or the IDHR and like contact information for those agencies. So that's required in Illinois. And so legal, like from just a risk standpoint, that's very important because if you ever find yourself in a IDHR complaint or EEOC, you're going to have to hand over your employee handbook, and you want to show that your company has strong anti-discrimination, anti-harassment policies. So along with that, it's like ADA and reasonable accommodation information. Reasonable accommodations come up all the time. So employees have to be able to know, or should, be able to know that they can look at a handbook and know how to ask for a reasonable accommodation and what the company will do and how they go about that interactive process. We obviously talked about that at will statement, which is only important if you actually, the rest of your handbook follows that, but it is important to make sure that to like put that at will statement in the handbook. So those are kind of like the really important stuff, but also like that's just from a legal perspective. I would say just from a company culture and like what you want your employees to know, you're also going to want to make sure there's information about like how do they clock in and clock out, how do they submit their time, what benefits do they receive, how much vacation, PTO, sick, that's like what the employees really care about, and that's what they're going to be like looking at the handbook for is like how much time they get off, if you have a maternity or paternity leave policy. So at our firm we use a checklist to determine whether or not like what policies should go in, and it's very long, and you also want to make sure a handbook isn't too long, so you kind of have to determine like what is best to put in there. But work like code of conduct, confidentiality. Ideally, you have a separate confidentiality agreement that is actually enforceable in a contract, but it's still important to have confidentiality language in the handbook. And then like a social media policy too is important because a lot of goes kind of hand in hand with AI, but you want to make sure that employees know, not to talk about client stuff on social media, to be professional, all that type of stuff.
Thanks. Max, what about training on policies and handbooks? I mean, should these be part of like new employee orientation or even incumbent employee training? And what kind of training is preferred or would you recommend?
I mean, I think it ought to be if it's important enough. I mean, let's assume for argument's sake that you have thought really hard about what you're putting in there, that you didn't just do something off LegalZoom or, chat GPT of what's a handbook or this, that, or the
Yeah.
other. And you've tethered this to your company. You've really put the policies, last time we talked about job descriptions like cultural and professional expectations and all of it in there. And you've seen fit to put that down. It seems to me that's exactly what you'd want to use to train people. The orientation or your first training opportunity is just that. It's an opportunity at compliance so that nobody can do the whole, well, I didn't read it or I didn't get it. That's not usually a defense, but it's not helpful if you actually want people to follow what's in there. So yeah, by all means do it. Because a lot of tests too, a lot of legal tests that we'll get to over the course of this year, over the various issues that we cover, are often the existence of a policy on its own will not be enough. You're going to need to show that it was effectively communicated, understood, and followed, and that it wasn't just a policy on paper, or you risk that turning into a weapon against your company down the road in litigation or otherwise, right? So I think, you absolutely want people to do that. Plus, if something does go wrong, and people need to report wrongdoing or the like, you want them to know what that stuff is. You don't want the first time they're made aware of a reporting mechanism, other than if they'd read a 300-page document or something, to be in a deposition when they say, I never got this, or I was unaware that that was the policy. It may or may not carry the day, but that's not really the point. You have a better chance to have the business run smoothly and everybody understand their expectations if they're trained on it. Plus, depending on the state you're in, you may be obligated to train on this stuff. Illinois, again, sexual harassment training is mandatory every year. So if the state circulated or offered free training as the policy you use, why would you not actively train people on that up front? You knock off the requirement up front and you ensure that everybody understands what the law and the policies are. So it just seems like good sense to me.
Thanks. Helen, what about addressing employee classification in handbooks and policies? That is like, addressing the definition or W-2 employees as along with 1099 independent contractor employees. I'm sorry, not independent contractor employees, independent contractors.
So you make, in a way, an important distinction that you didn't realize you were making. In a handbook, it should talk about different employee classifications. Employee is the operative term. So it should discuss who is part-time, who's full-time, what the criteria is for part-time, full-time, to be exempt from overtime, and all those definitions. A 1099 is not an employee. And so you don't want to cross the lines by referencing 1099s in your handbook because they are not employees. And if you do so, you may unwittingly convert them from essentially their own business to an employee. And then you will have classification issues that perhaps you misclassified a contracted business owner for an employee, because that's really what a 1099 is. A 1099, we might call them a gig worker, but they are not an employee. Truly, a 1099 is someone that has their own independently established trade, business, and profession, which means they are not your employee. And therefore, they really should not be bound by your handbook, because that really is what makes the distinction, that they're not under your control. If they're under your control, then you should be treating them as an employee, bring them on as an employee, and then of course it would be subject to, the handbook.
Thanks. Do you think it's advisable to even give 1099 contractors some sort of policies or procedures, a handbook, something like that?
I mean, it really depends. So, for example, some policies and procedures. It depends what you mean by that. So, for example, let's say you've contracted with an independent contractor to work on, let's say, a client matter of yours, because you don't have that skill or expertise in your business, so you have to bring in a separate business to essentially work on that client matter. They might need to sign a confidentiality agreement, and so that might be a certain kind of policy that an independent contractor would need to sign because your client might require it. But that's different than being bound by your handbook that might have a confidentiality paragraph in your handbook. Because remember, they're not your employee. So you don't want to extend your handbook to them, but what you would want is you would want to have separate standalone, let's say, agreements that maybe you incorporate into your master services agreement with your independent contractor, that they agree to certain things that might be similar to what's written in your handbook, but it's not from your handbook. You're not converting them to an employee by saying, hey, follow the rules that we require our employees to follow, because they're not your employee. So you really have to be very careful to distinguish some, requirements that are needed to perform that job for your business by that third-party service provider, what we call a 1099, and be careful not to blur the line and to unwittingly treat them like an employee.
Thanks. Katie, every resource I've ever looked at advises for having a progressive discipline policy. What does this mean? And do these types of policies really help? And how dogmatically should a business adhere to these policies?
So a progressive discipline policy is outlining how the employer handles discipline in the workplace leading up to potentially termination. So it's like a warning system. Like if you do this, if you're late twice in a row, you get one warning. If you're late again, you get a second warning, and so something like that. And a lot of companies have different tiers for like these that's why it's called a progressive discipline, is because like
Yeah.
it kind of like goes up and then eventually you're fired, right? um it really depends on your company, right? So like most big companies who have hundreds, thousands of employees and many different teams and a lot of managers, it probably makes sense to have a progressive discipline policy, because then you can train, like Max was just talking about, you can train the managers on how to handle certain situations instead of just saying, okay, well, you messed up once, like maybe next time you'll get fired. Like it's that's a little bit more of a subjective standard. Um, and so in those sense, it kind of makes, in those instances, it makes sense to have a kind of a more formal policy that managers follow. No matter what kind of business, I always, like the handbook should always say that even if they have a progressive discipline policy, that the employer reserves the right to terminate at any time, at their discretion. So if an employee does something really bad or like, really, you know, violates like egregiously violates a policy, you shouldn't have to be like, okay, you get a warning for that. You know what I mean? Because so it's important to kind of make sure that like an employee understands that if there's a progressive discipline policy in place, that doesn't mean that they can't be terminated immediately if the company determines that would be in the best interest. For smaller businesses with, less than 50 employees, generally, I would say I think it's kind of unnecessary most times to have a progressive discipline policy, because usually for smaller businesses, they can kind of handle things on a more informal basis. But it really just depends on kind of what the employer wants, and like they know their workforce better, right? So, but at the end of the day, like it is important to make sure that the at-will employment is adhered to, and that, if someone egregiously violates a policy, they can be terminated. But this also goes back to the question Max answered earlier about training. So not only should like all employees be trained on these policies, but I think it's almost even more important that like managers and supervisors be trained on the policies, because they're the ones who are going to have to kind of like implement a lot of this stuff, especially if we're talking about the progressive discipline. And there are so many times that I talk to clients and they don't even know what's in their handbook, and they're like, our managers don't know what's in, you know what I mean? Like they don't know. So if they don't know, how are they going to be able to implement this with their teams, right? So I would also consider, having maybe a general orientation or training with all employees, and then like maybe of a more manager focused training on like how to, like what if someone comes to you and say that they think they've been harassed? Like, does a manager know what to do in that situation? What if someone goes to a manager and says they've been having a health issue, but maybe they don't say they need a reasonable accommodation? Like from the employer's perspective, that should ring a bell, and they should say, well, we need to talk to them about potentially having an accommodation. So making sure that there's like different levels potentially of trainings as well.
And just to let attendees know, the dress code, the first bullet point dress code, and the last one, use of company property, those aren't highlighted for any particular reason. I just think that was maybe a glitch or something. So they're just in the same priority as all the other bullet points. Moving on, Max, what about having in a handbook something about like no union or no collective organizing, having that sort of provision in a handbook? Can a company do that?
That depends. How eager are they to end up in front of the National Labor Relations Board at a contested hearing?
Yeah.
Yeah, I mean, the general look, right now, what the NLRB does or does not do, or even can or cannot do, is a little bit up in the air, or at least it was last I read. Questions about quorum and who are the actual commissioners and what are they actually even going to enforce in terms of labor violations right now. And I think, as a general matter, whenever the administration switches sides, I'm not taking a political position on anything. There tends to be different priorities and enforcement and how things get handled by the National Labor Relations Board. That said, as a general matter, no, you should not have a bar on what we call concerted activity or the rights to organize, discuss unionization, and act together about terms and conditions of employment. Like, you can't just say you're not allowed to talk about this. That is a right folks have. A handbook that tells people they can't do union organizing or the like um, is what we would consider like chilling activity and the exact kind of thing that gets the NLRB involved or gets them to pay attention when it's normally functioning. Um, and you don't even need a union in the workplace for that to be the case. Like, I have seen it when I was in my first job. We had cases against government contracted shipbuilders up and down the eastern seaboard, many of whom were in right to work states or states where they had been more successful at kind of pushing off big union membership. And what I would see in those handbooks, and I can't say who vetted it or not, was things like, hey, this is a non-union workplace. We like to keep it that way because it lets us communicate with you guys directly and handle things on one-off bases. If a union gets involved, it changes the labor dynamics. Set aside whether I agree with that or not, I've seen things like that that are less coercive and threatening and more, hey, we don't want this. I'm not advocating it, but I have seen that. What they can do is content neutral conduct and productivity rules. So, like, preventing folks from doing organizing during working hours, you can prevent that. No distribution of union materials during the same time and in working areas. But it needs to be uniformly enforced, and it can't just be applied to labor organizers. It's got to be about personal or non-work related items. So I think I misspoke at the beginning. So, you can control productivity and disruption, but what you cannot do is make it a pretty transparently anti-labor organizing or anti-union policy. That is the kind of thing that will get you into trouble if and when the NLRB is functioning as it ought.
So just to clarify one thing, you mentioned disruption, like controlling disruption. The NLRB is very liberal even when it comes to defining what disruption is. So I've seen it before where I would say mildly violent behavior was condonable by the NLRB. So just be
Yeah.
very careful.
Yeah, I mean, I've encountered cases like COVID is sort of my favorite place for examples to go on a lot of the issues we run into here, because that's when it was this weird bubble about how employees and employers all sort of operated. Like, I saw more kind of concerted or group activity from non-union workshops than I've seen at any other point in my career. And I saw things like people getting petitions signed of, like, especially early on before things got really politicized and vaccines and masks became fighting words. Hey, you're not enforcing social distancing and hand washing and masking here, and people are getting sick and this, that, and the other, and getting petitions signed and people getting fired for that sort of thing. So, you know, I think I think there's this notion for a lot of employers, especially those that tend to be aggressive with their workforces, that letting people gripe or complain about things is somehow going to hurt the company or lead to mass unrest. And my first question would be, what are you doing to your workforce that they're so upset that, like, even the mention of, like, distrust or disenchantment with the management is going to lead to, like, a revolt? But more broadly, I think if you don't give people the opportunity to grieve or just handle things in a calmer way, you're going to it's like the old John Kennedy quote about, like, those who make incremental change impossible make revolution or radical change like inevitable, that sort of thing. Like, give people a chance to air stuff out. If they're whiners and complainers, usually they're going to out themselves and you'll be able to deal with it and paper the file. If it's a real problem and you're getting that complaint over and over and over again, you might at least consider dealing with it rather than just shutting up the complainers. It's much more likely to end the complaints.
Yeah, thanks. Um, Helen, this is always a really controversial aspect of handbooks and policies. Can you have language in a handbook that waives an employee's claim against the employer or certain legal actions, uh, and or even like mandating arbitration for the employee?
So let's separate those two things. It is completely void and unenforceable if you have an employee sign a document that waives their rights to laws that are absolutely guaranteed. For example, Wage laws. Okay. You can't have an employee waive their right to get paid. I don't know any state in this country that doesn't have a local wage law in addition to like the federal wage laws. Usually the local wage laws are more robust than the federal, but even the federal, there are steep consequences under federal law, for instance, under the Fair Labor Standards Act, for not paying your employees, or if they are not exempt from overtime, for not paying overtime. And no how, way, shape, whatnot can an employer have an employee waive their right, for instance, to get overtime. So the short answer is no. An employee cannot waive certain rights that are absolutely guaranteed them by law by signing a handbook. Arbitration is interesting because technically speaking, an employee can waive their right to go to court and agree to arbitrate claims against the employer if it's supported by what we call consideration, meaning you give them something in exchange for them agreeing to this arbitration. So if you just throw, let's say, arbitration in the handbook and say all employees have to agree to arbitration and sign off on the handbook, that probably is not going to be enforceable. If, however, you give the employee a standalone arbitration agreement and say, we want you to sign this document, we want you to agree to arbitration. If you don't agree to arbitration, we are going to terminate you. Then there's an argument to be made that there is valid consideration for that arbitration agreement because the fact that you have a job, the employment itself, is the consideration for entering into that arbitration agreement. So just having a reference to it in the handbook or a whole policy in the handbook is not going to cut it. It's got to really be a standalone document that the employer can show the employee had an opportunity to read it, to go over it, to have valid consideration for entering into the arbitration agreement. Now, what you could do is you could reiterate in the handbook the arbitration agreement. Or for instance, it might even be possible to have another document that says, in exchange for the employment, you agree to the arbitration. Policy surrounding the arbitration and what we require for arbitration is in the handbook. Go see the handbook for more details about arbitration. That might be okay. But again, there has to be a separate signing, valid consideration in exchange for that arbitration agreement. And arbitration is not allowed by law in all circumstances. For example, there's a law that got passed during the Biden administration that some things can't be arbitrated, like sexual harassment claims. You cannot force an employee to arbitrate sexual harassment claims against the company. So yes, in theory, an employee can agree to mandatory arbitration and be bound by that mandatory arbitration agreement with an employer, but not for all kinds of claims.
Thanks. So I'm going to ask this because I see this come up occasionally. There's two parts to this question. What about waiving unemployment compensation? Can a handbook next say no?
No. I mean, there's certain things by law generally an employer cannot require an employee to forego. So for example, right, I mentioned compensation. Other kinds of benefits, like under what's called the ERISA law, the Employment Retirement Income Security Act. So for instance, if the employer gives, let's say, 401k benefits, the employee can't, and they've already earned it, it's in their account. The employee can't say, "Oh, forget it. Take back the money. I don't, you can take it back." They have an absolute right to what's called vested benefits. So compensation, benefits,
Workers'
unemployment
compensation?
is another thing. Workers' compensation, that's another thing that can't be waived generally as a matter of law, that you have the absolute right to certain kinds of benefits if you meet the criteria for those essentially government mandated benefits.
What about, I see this one come up too, overpayment, where the employer pays the employee mistakenly pays them too much and they want to recover that?
So an employer, can, but there are certain ways to do it. And, that sometimes is grounded also by state law in addition to federal law, that only a certain amount can be deducted from, let's say, a paycheck. So if, let's say, by accident, you give an employee 2 paychecks, if you realize it right away, yes, you can, claw back that 1 paycheck right away. But if you don't realize it right away and you realize it, let's say, months later, then you have to look at what the state law is and the federal law in terms of what you can deduct going forward from paychecks, and in some states have the employee sign off on it.
Yeah, because I mean, you can't, some states may not permit you to have a blanket policy covering all situations or all employees.
Yeah, they might have to sign off on it at the time that the deduction is going to be made from the pay.
Yeah.
That's the case in
Eh,
Illinois, right? And this is
Yeah.
something I see all the time too, is handbooks will always say, in the event of an overpayment, or if there's like a damage to company property, or if you don't return your
Oh,
uniform,
yeah. Damage company property
yeah, the
uniforms.
company
Yeah.
will deduct from their final paycheck. And I'm like, you could keep this in, but just know you can't actually do that a lot of places. And then they're like, well, what if we get the employee's agreement in Illinois? Because in Illinois, the employee has to agree at the time the deduction is made to the deduction. And they're like, well, what if they agree that they will agree at the time? And I'm like, okay, well, now we're getting into, and that's probably not going to work out for
Yeah.
you. But not all states are that strict, but
Restrictive. Yeah.
most states do have some language about like what you can claw back.
At the federal level too, and I apologize if somebody said this, but the deductions also can't drop the employee below the minimum wage for any period of time under the FLSA. So you just, even absent that stuff, you always have to be careful of like, well, they're just not getting paid for the next 3 days. It's like, no, that's not, you can't do it that way.
Yeah. Any practice really, or any practice or policy that drops the employee below the minimum wage is pretty much illegal per se. I mean, strict liability.
Yeah.
So, well, Katie, let's take a different path here. What about translating policies and handbooks into non-English language? Is this a good idea? When do you do this? Why would you do this?
Well, again, if you have employees, a vast amount of your, workforce that maybe doesn't speak English as their first language, then you're going to want to translate the handbook into whatever language. Because the point of a handbook is that the employees read it and understand it and will abide by it. So if they can't read it, if English is not their first language, then yeah, you should have it translated. But it really, again, depends on your workforce. If you have a small workforce and everyone that you know of are English speakers, I don't see a reason why you necessarily have to have it
Yeah.
translated. But if you just kind of again, it's kind of going back to like just taking a one size fits all approach. If you just have a handbook that's in English and half your workforce, isn't fluent in English, or English isn't their first language, like how do you expect them to be able to acknowledge and like actually read the handbook? And that goes for all, the workplace posters that employers are required to have. Most of them, I think, are available in Spanish and I think some other languages too. So
Yeah. I mean, there's a lot of
yeah,
states that have multiple languages for them: Polish, Indian, Hindu, whatever.
right. So it kind of goes back to that. It's just like all of these policies and all of the procedures should be specifically for your business and your workforce. And it's just kind of like, I mean, I hate saying common sense because like, what is common sense? It doesn't seem like there is a lot of, but it's just like, if you have people who don't speak English, you should probably have a handbook that's translated so that they understand it.
There are
Right.
also some policies, not necessarily a handbook in total, but there are some policies that certain state laws might require to be put in writing. So, or certain based on certain industries. So, for instance, there could be certain industries, like let's say restaurants, that have a lot of Spanish speaking employees. Then there could be some states that actually mandate certain policies, such as sexual harassment, and other policies must be provided in the local language as well, such as Spanish. So, again, there's no law that requires an employer to have a full-blown handbook, but there are a lot of jurisdictions that require certain policies to be in writing, and sometimes those policies, it is mandated that they have to be in languages other than English.
Well, there are some laws that require policies or handbooks after government contracting, I believe. I mean,
Yeah,
I
that
think
could,
those are
right.
the
So
only
it could be, right. There could be, let's say, certain government contract opportunities that to be eligible to win one of those government contracts, you have to have a handbook in place. That is true. But I mean, correct me if I'm wrong, I don't know of any like
law.
federal
No.
law that requires, or state law that requires every employer to have an actual written handbook.
I'm not aware of any of those either. Um, thanks. Max, dispute resolution in handbooks. How should workplaces address these types of policies? What's good what are indicators of effective dispute resolution policy?
So I think there's different components to it, right? Because I've seen some where it's like, oh, if people are not getting along, they have to go to these mediations, and I'm a little incredulous as to the efficacy of those. I think it's sometimes it's useful, because I've found that people in the workplace sometimes act like little kids on the playground that my wife teaches in the third grade. Actually, sometimes the third graders are better than them, or even my
Yeah.
kindergartner. Like they just people get so petty and silly and like petulant. Um, so I don't know that those are always necessary, though I've seen companies use them. I think there's different parts to this. So start with clear reporting channels. Like, if employees don't know where to go, you've already sort of lost the plot. So, step one is I think make sure there are a lot of different reporting or complaint mechanisms that exist. I know some employers like to think about, well, if I give people a chance to complain, they're just going to do it. And it's like, well, yeah, but if you give them that and you take their stuff seriously, they're probably going to complain less. And they need to know how it is. Like you don't want you want to give them, if possible or useful, an anonymous reporting mechanism. You don't want single channel reporting, i.e., it must go through a person, or we're not going to like it'll be as if it didn't happen. There are so many reasons that's really dangerous if that person's a harasser or is doing something that's illegal that's leading to the reporting. It's as if you have no effective reporting mechanism. So really be careful about that. You want good anti-retaliation statements that make clear that people are going to be taken seriously. You may or may not get what you're asking for or get what satisfies you, but we will hear you, we will take it seriously, and if called for, we will do a robust investigation. You probably want to let them know what the results will be or how they will or will not be informed, because one of the frequent complaints I hear is, and nobody told me what the investigation did or what they did to this person. And it's like, well, they probably should have, manage expectations up front. Um, you want to emphasize that complaints will be taken seriously and that things will be handled confidentially to the extent they can be. And that's key. Like I always think back to The Office as a guide for just so many labor violations, but
You
also,
mean the TV show?
yeah, the TV show.
Okay.
There was an episode where HR did an ethics presentation, and Steve Carell's character promises blanket immunity to this person who admits they've been having sex in exchange for free office supplies with a vendor. And, it sets off this tidal wave of events and nonsense. Obviously, that's not a common thing, hopefully, but you don't want people to have unrealistic expectations about what HR can and cannot do. It's not a criminal mechanism. They can't give you criminal immunity. They can't do things like that. What they can do is follow the law, take your complaints seriously, investigate and document where called for, and the like. I think, when it comes to investigations and progressive discipline, to the extent you employ it, depending on, like Katie said, whether it's called for or if you're too small for that. If it's a two-person company, I don't really know how that's going to work. Um, you want people to understand what an investigation would entail, what a likely or realistic timeline might be, and then what disciplinary mechanisms exist. And I want to just mention the NLRA again one more time, and that there's not going to be anything done to chill complaints or legitimate concerns about the workplace. You don't want policies that like restrict people from talking about things in the workplace with coworkers or require confidentiality about literally everything in a way where it's like you're sort of sitting there like on pins and needles about, am I even allowed to open my mouth? So be flexible, document well, and make sure there are clear expectations, I think.
Yeah, so, I mean, you raise an interesting point. I'll pose this to all three of you as a follow-up question. What about mandating that employees cannot talk about issues concerning compensation and benefits?
That'd be unlawful
Yeah.
because it would violate the National Labor Relations Act, the requirement that employees are allowed to discuss terms and conditions of employment. I believe it is Section 7 in the National Labor Relations Act, if I'm not mistaken.
I believe you're
So
right.
that's a big no-no.
I mean, so you can't like even say our salary data or compensation data is confidential. Do not discuss this with amongst yourselves or
Well, here's a
You
with
can't,
distinction
others.
though. There is a
yeah, you can't
distinction.
disparage it outside
Yeah.
or not
So
disparage. Sorry, go ahead, Helen.
no, so what I was about to say is that let's say your job at a company is HR. And actually this happened to a client of mine. It was a smallish business, less than 15 employees. And there was a person who wore many hats, which often happens in smaller companies. They're the controller, they're the HR, et cetera, et cetera. And this individual was very disgruntled that they didn't get a certain level of compensation or a certain bonus, which was absolutely discretionary at the end of the year. And they started looking up people's, salary information, which they should not have, and started, asking other employees, well, what did you get? And sharing what they had and what other people had. And that is a no. It's one thing to say, listen, I'm not happy with what I got. What did you get? And you could, if you want to tell me, tell me. But you cannot go into the employer's databases, look up information, especially if you are in that kind of a role. That's confidential information. You should not be sharing because you have privy to other employees' information, what other employees earn in the place of employment, and sharing that information. That is an absolute no-no and a breach of your obligations, your duty of loyalty to the company. And that is very different than employees on their own discussing terms and conditions of employment and sharing with one another without being compelled to or without the beans being spilled because you inappropriately accessed your employer's confidential information,
Hmm.
from sharing on your own what you make and what other people make.
Thanks. So I'm going to throw this out to all of you. What are some of the things that are the most essential things you look for when you're reviewing a handbook and policies?
So what I do is sometimes people have something in writing, or sometimes what people will do is they will have gone on let's say the internet, or they started putting together something themselves. And I already know I'm not going to use that, but it's really helpful to me because I'm able to see what is important to this employer, like what sounds good to them, whether it is lawful, unlawful, at least it signals to me what they are looking for in a handbook. And then I will have a very long conversation in which we go over certain points and say, hey, why did you put this in there? Is it because it sounded kind of nice and you thought maybe you were supposed to have it? Or is it something that's really important to your business? I'll find out about their workplace culture, about the kind of image that they want to have, what kind of things have been problematic for them, what they want their requirements to be. And my recommendation is always less is more. If you don't have to have every single little detail in the handbook, because then you lose certain flexibility. And sometimes you need fluidity and certain things happen that you're not anticipating, and you need to know how to react in that situation. So sometimes people, or oftentimes folks, do have like a sample or a template or whatnot, but sometimes they're just turning to me to put that together for the first time.
Anyone else?
Yeah, I mean, I always start with if they don't have a handbook already, sometimes they have a handbook and it needs like a full review or just maybe an update. But if they don't have a handbook, I always start to ask, the first questions are like, how many employees do you have? Obviously, what type of business are you in? What states are you in? Because that depends if they need, if they need state specific addendums. But then also like what problems are you running into and what issues are you currently have with your employees? Because that's usually what led them to like have a handbook. It's like, oh, we're having attendance issues, or people don't understand. We keep getting questions about our vacation time, even though we've told, you know what I mean? Like that type of stuff. So, but yeah, Helen's suggestion is a good one. Is kind of like if someone starts putting together a handbook and they have these policies in there, it's like, okay, do you just think you need to have this, or like, you know what I mean? Like, why did you put it in? That's a good, kind of a way to approach it.
Yes, to everything they said. I don't draft these, so I'm looking at this from the other side, but also think about what industry you're in. Like if you are in certain manufacturing or other just specific industries, you may have regulatory obligations that require you to put certain information in there, like OSHA, the SEC, Sarbanes-Oxley. Like there's different there's different statutory requirements or things that if you don't have, like, so for example, if you do manufacturing and you don't have a lockout tagout policy for like how a machine needs an auto shut off if there's a problem, with the idea that if somebody sticks their hand in there, it's going to get ripped off. You can get fined by OSHA for not having a policy or not following it. And so like you need to also think about what industry are they in and what are the regulatory obligations you have and what sorts of things can get you into trouble for not notifying your employees.
Thanks. We'll let you have the last word on that, Max.
Nice.
Helen, if you can, go to slide number 4. I left out one of our sponsors in my introductory remarks. I just want to make sure I don't do that again. I believe it's MaxX Asset. They're one of our sponsors, as well as the National Law Review. We're at the top of the hour. And with that done, thank you everybody for attending. Thanks, Max, Helen, and Katie. And we will be back for the third in our series. Yeah, there is MaxX Asset. Single asset sales online. We're going to be back for number 3, show them the money, wage and hour compliance. That's March 19th, exactly a month from today, also at 2 p.m. Central Time. Thanks, everybody, and see you then.